Viewers, welcome to the Personal Injury Law Show. This show talks about everything coming to law with personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me today I've got a senior partner law firm in transport accidents, Don Maffia. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And a senior lawyer in transport accidents in a law firm, Aki Manua. Good evening, Aki.
Good evening, Tony. Hello, viewers.
Viewers, tonight we're going to give you an update on transport accidents and mishaps on the road. Very nasty mishaps, Don.
But Tony, before we get into that, let's talk about what's in the news.
Viewers, there's a lot of stories and we just don't want to confine it purely to personal injuries, but the first story is a very, very tragic case. It's a school that's been rocked by the death of a young man whose wife was teaching at this school, Don, and he had two children attending that school. Tell us a bit more about what happened to her.
Well, he went to pick up his kids, so madness time where everyone's coming in now to pick up their children from school, and a lady who was picking up her grandchildren lost control and went through a fence and actually hit Mr. Booth and unfortunately killed him, Tony. Very tragic circumstances.
It is tragic. Aki, you've got something similar to this against one of the other private schools in Melbourne. What are the rights of the family in this situation?
Well, that's right, Tony. So the rights of the family could be against the driver if we can prove negligence, as well as the school if we can show that they could foreseeably see that this was a risk and it was quite possible that this would occur.
Well, Don, as soon as she's lost control, I think the case is reasonably clear against the driver, wouldn't you think?
Well, look, it is, Tony, but at the same time, obviously the school will have some responsibilities. I mean, at the time, this is drop-offs and school pickups, Tony. They are absolutely crazy times.
They are
kids
crazy.
running around, cars running around, people want to get to where they have to go, parents dropping off their kids, have to go to work, drop off quickly and run off. It is crazy time. It is madness. And schools have responsibility to ensure proper traffic control mechanisms as well.
Well, supervision is a critical aspect of the whole thing.
Well, yes, and make sure that they're safe.
Yep.
This case, yes, she did lose control, so maybe the school is exonerated in the sense of there's nothing they could have done. But there's many cases, and as you said, we have cases where school pickups, the school have failed to ensure proper safety measures or mechanisms to stop that. So, and look, the other thing too, Tony, is a lot of kids, students saw this accident.
Yeah.
So they will.
So they might have a claim too. Yeah.
Correct, for nervous shock. So there's plenty of things, but
it's a very, very sad case. All right, let's move on. This is another sad case. A truck driver has an accident and then decides to bolt, and they pick him up 16 kilometres away from where it happened. Aki, what happened there?
Well, Tony, this was a tragic accident. It was a fatality, so someone did pass away in the accident. And then the truck driver's missing, and they found him, I believe it was about 30 hours later, hiding out in a shed somewhere. So, I mean, an adverse inference must be drawn in those sort of circumstances.
But the thing is, Tony, I all thought he was dead because his semi-trailer crashed with a four-wheel drive.
Yes.
And the truck was referred to as a fireball, so it was incinerated. And I didn't know if he was alive in there. So 30 hours later, he just pops up. Now, the thing is, Tony, the police have not said that he was at fault for the accident or was a cause of the crash. What they do and what they have charged him with was failing to stop and failing to render assistance.
Well, if he had any under the influence of alcohol or drugs, by taking off and being outside that window of opportunity to test him, they can't possibly charge him with anything else, can they?
Well, they can't because they're within the 3-hour window. But the thing is, he's being charged with failing to stop and render assistance. So everyone must realise, and the viewers, that there is an obligation. If there is an accident involved in an accident, you have an obligation under the law, or you can be prosecuted, as in this case, to render assistance.
It's abhorrent to think that he'd bolt, the car's on fire. He should have gone and at least tried to help.
Oh, that's right.
I mean, these couple of young people could have probably been saved.
Exactly, that's right.
And one thing, Dodie, that our viewers as well may be concerned about, if they go render assistance, and they do something wrong, something else happens, they may be sued. But
not in these circumstances.
But there is some protections under the Wrongs Act, the Good Samaritan protection. You know, there you go. This guy, he's run away for whatever reason, but now he's being charged for failing to render assistance.
Which is not going to give him much. You know,
wait to see.
It's a lot different if it was a culpable driving charge, if he had alcohol in his system or something like that.
Exactly.
But anyway, look, it's a very sad case, any which way you look at it. All right, this is definitely the nanny state. There's schools that now are preventing kids from bringing watermelon and bananas in their lunch boxes because there's a spiral of allergies that's out of control. I mean, is this nonsense or what?
Oh, look, Tony, I think they're taking it a step too far. We've already banning, we see soy, wheat, eggs, dairy, seafoods, nuts, a whole lot of things that are being banned at this stage. I think they're taking it a step way too far with this one.
I never remember even going through school, Tony, being prevented to bring some type of food. Now it's getting to a stage where you just can't put anything in children's lunch boxes.
What are you talking about? When I was at school, they used to force you to drink milk even if you didn't like it or if you had an allergy to milk.
I remember going to kindergarten, they used to give you, that's right, they used to give you milk at the end of the day.
Hey, viewers, the salad salmonella problem, apparently there's been 200 people affected. I reckon the number's higher than that. These are probably the people that have complained or reported the situation, because I'll tell you what, we had 3 people in our family affected by this. Aki, what can you tell us about this?
Oh, well, you just wouldn't expect it to happen in somewhere like Australia. You think, okay, in other countries you might avoid drinking the water, but you just wouldn't think that. You'd think that there'd be proper controls over this sort of stuff to avoid it ever occurring.
Well, Don, we had this problem with the berries that came out of China. Do you remember there was a salmonella outbreak then?
Yeah.
And that was only last year, wasn't it?
Yeah, well, this is made in Australia. This is made in Victoria. And the thing is, these packets are promoted on the basis that you don't have to wash them. They're prepared, so just open pack and eat them. And not that washing the leaves in this case would have changed anything, because
it had to do with
the
fertiliser again, didn't it?
And the thing is, Stone, is 200 people are past 200 salmonella. Now, the thing is, with these claims, unless there's any permanent injury, there's really no recourse for compensation other than medical expenses and the like.
You'd be surprised. I mean, I've got clients that have had incidents like this many years ago, and they're still complaining of bowel symptoms, and it's triggered irritable bowel and other things. So is it data discoverability an important issue where, you know, something might come up in 10 years' time? Yeah. And that's when you first discover you've got a problem.
So for the viewers, there is, to sue for in these circumstances, you've got to prove a significant injury, which is a permanent injury assessed.
More than 5%.
Correct.
Yeah, under the guides, which is pretty high, isn't it, Aki?
Oh, it is. It's quite difficult to get, especially with gastrointestinal type injuries. It is quite difficult to get over that threshold.
Well, hopefully nothing permanent comes out of all those.
Oh, you'd be surprised. Now, this is a good one. Infrastructure Australia report says you should scrap rego fees and fuel excise in exchange for charging for road use. Well, we've already got the fuel excise, we've got the regos, and we're paying on Eastlink and everything else. So I don't know how this is going to help. So it's more a case of get people off the road. That's what they're trying to do, isn't it, Aki?
Well, you'd think so. I think a lot of Australians have a misconception that road use is actually for free, because particularly with the fuel excise, we don't see it on the dockets. It's just a tax charge to the fuel pump. So I don't see a difference in charging for road use, because you're already paying to use the roads, essentially.
Well, Don, how many cyclists don't have cars?
Wow, yeah, plenty. So I'm not sure, Tony, that's going to change anything. I mean, road use changes to road use from regos. I can't see how that's going to help, but one, save money, because at the end of the day, you still, everywhere you go, it's going to be roads that you have to use.
Yep.
Unless you live in a city. I'm sort of.
I think it's trying to encourage people to use public transport, which is not really working too good anyway.
Which you have to pay for anyway, which is increasing. So look, I'm a bit perplexed. I'm not sure.
We should get someone from
that work at all.
Someone from the RACV to come and talk about this. Anyway, viewers, we've got to go to a sponsors break. Stay tuned. After the break, we'll give an update on motor vehicle accidents and transport accidents. Viewers, welcome back to the show. Today we're going to be talking about transport accidents and give you an update on what's happening in the courts. And Don, by the way, we're probably the only TV law show that's actually trying to educate the public.
It's correct, as far as I'm aware.
Others, is there?
As far as I'm aware, there isn't.
Aki, have you seen any others where... Anyway, the good thing about it is people are watching it for that reason, to learn a bit about the law and what they can and can't do and what their rights are, which is why we're here, viewers. Anyway, Aki, there's an interesting case of Ning and McGrath. It's a Supreme Court of ACT decision of last year. Can you give us the facts?
Correct. The accident actually occurred in 2008 on an autumn evening, so it was quite dark at night. We've got Mr McGrath, who was travelling along a straight road. Mr Ning enters a T intersection, turns right at the T intersection, but fails to give way to Mr McGrath, resulting in a collision.
Just curiously, what was the speed of these two vehicles, Don? Do we know?
No, I don't think they were detailed, Tony, but it was more of a question of, one, obviously Mr Ning failing to give way, and then in defence to that claim, he actually pleaded that Mr McGrath had contributed, was negligent for failing to properly be visible. In this case, what happened with Mr McGrath, he's riding a motorcycle which had a faulty headlight, and it was at night, and he was wearing dark clothing.
Can I stop you there? So it's a case of Mr Ning being at fault, Aki, correct?
That's correct, Tony. So at first instance, and just looking prima facie at the circumstances of this case, you'd think that Mr Ning was at fault for failing to give way. It's a clear breach of the road rules.
So in the first instance, Aki, the court found for Mr McGrath 100%.
That's right, Tony.
Okay. So Mr Ning, Don, is dissatisfied with the decision, or
Goes to
his
Court of
insurer
Appeal.
is.
Yes.
And they say, no, look, there's been mistakes made by the court, and in the first, some of the grounds of appeal were that the court erred in rejecting Mr Ning's evidence that he did look to his right before turning to the intersection.
Correct.
B, that the court erred in not making a finding of contributory negligence against Mr McGrath for Mr Ning's failure to take notice of Mr McGrath that he was wearing dark clothing, had a defective front headlight. That's what you said before, Don. Elaborate a bit on that.
Well, Tony, just further to the facts of the case is that when Mr Ning was turning right,
Yes.
he stopped, allowed one car go past, so he obviously saw the first car.
Yes.
And then proceeded after the first car and didn't see Mr McGrath, and the collision occurred. Mr McGrath's evidence, he says that he actually saw Mr Ning stop and actually saw Mr Ning looking to the right.
Yep.
And thought, okay, well, this is safe to go right through. And what Mr McGrath did is that when he saw Mr Ning come out, instead of pressing the brakes or anything, he actually tried to swerve.
So he just kept going.
Yep. So that's one of the allegations as well. So there was two grounds of contributory negligence that Mr Ning's lawyers, in this case insurer, argued and said, well, one, when the respondent saw that the appellant was going, or when the respondent saw the plaintiff going through the intersection, he should have brought the motorcycle to a halt, should have stopped rather than swerving around. And the other allegation was, as I said,
Wrong voltage on his light.
Correct. So faulty headlights on the motorcycle, plus also wearing dark clothing at night.
Well, Aki, this highlights the fact that the law is basically saying you've still got to look after your own safety.
Correct.
You just can't let everyone else worry about you. You've got to look after yourself as well, correct?
As a road user, you've got to discharge your own duty of care as a road user. It's very important to make sure that you've got the correct lighting, correct visibility, particularly when riding a motorcycle or, for example, riding a bicycle as well, riding a push bike. You need to make sure you're visible to other road users.
Yep. And Don, they knocked off 30%?
They did. So on the first ground of contributory negligence, which was alleged by Mr Ning's insurers or lawyers, the court said that a decision made in the agony of the moment doesn't necessarily mean it's contributory negligence. Okay? So hindsight's always good, but in this case, they're saying, look, the fact that he didn't stop, Mr McGrath, and tried to swerve is not regarded as contributory negligence.
Well, Don, just on that point there, it seems to infer that if Mr McGrath had stopped, this accident would have never occurred.
Well, correct, but they're saying it was made in the agony of the moment. I mean, it's a split-second decision.
It could
go either way.
On that logic, Aki, I mean, McGrath could have lost outright. Yes?
Well,
no?
yeah.
Or at the very least, it could have been a 50-50.
Could have been more. I wouldn't think he would lose outright because at the end of the day, Mr Ning failed to give way.
Okay.
And put him in this situation where he had to make a split-minute decision. Obviously, probably we don't know if it was a right or wrong one because hindsight is always easy to do, Tony, but the court said, look, that wasn't contributing negligence. But then went on and said, well, the fact that he had a faulty headlight, he knew about it and was in dark clothing, that is contributing negligence because he actually went out in a situation, put himself in danger.
And 30%, was that a fair assessment, you think, Aki? I mean, you know, it's very sort of arbitrary in some respects, isn't it?
That's right. I suppose it's up to an individual looking at the circumstances. I think it can differ significantly between who's looking at the circumstances themselves. But, I mean, 30% is quite significant. It can mean a significant difference in what you actually
in
receive
damages.
as compensation.
And look, the court described Mr McGrath's actions on failing to have proper headlights, but also wearing dark clothing, as a risky enterprise, Tony.
Yep.
So go on the road.
Well, based on what you've
risk.
just said, I would have thought he could have lost 50% on this.
Oh, I think 30% was fair.
Okay. Viewers, whilst we're talking about the issue of contributory negligence and looking at the respective parties' relative culpabilities and apportionments, this takes us into the case of nominal defendant and Bacon. It's a 2014 decision of the New South Wales District Court. Aki, can you give us the facts of this case?
So, Tony, this accident happened in 2008. We've got Miss Bacon, travelling down an unsealed road, and Mr Cliff driving in the opposite direction. Both vehicles are travelling in the middle of the road because, as you know, with those unsealed roads, they're quite damaged on either side. So it was common knowledge that a lot of people would be driving down the middle of the road. What happened here, Tony, is that Mr Cliff saw a prime mover travelling before Miss Bacon, pulled over to the side of the road. As he merged back into the centre of the road, he collided with Miss Bacon's vehicle.
Don, there was evidence of dust being in the air and vision not being clear.
Correct.
So is that the cause of this accident?
Well, what the cause was, Miss Bacon was behind the prime mover and that was picking up dust, so a very dusty road.
Yes.
And she couldn't even see, I think her evidence was that she couldn't even see a car length away. So much dust was being picked up by the prime mover.
So did she obviously didn't keep a safe distance?
Well, she did, she slowed down.
fast?
No, I think it's just a road turn. You've got a big prime mover on a country road with all this dust. And Mr Cliff, coming the other side, saw the prime mover and saw a cloud of dust behind, but couldn't see behind the oncoming prime mover.
Okay.
So what he's done is he's moved to the left. We think the evidence is a bit inconsistent in that regard, where they moved to the left. It was a bit cloudy. And then after he passed the prime mover, after they passed, he starts moving to the middle of the road.
Yep.
Whereas Miss Bacon,
Stays in the middle.
she was in the middle, but she started slightly diverging to the left as well, but didn't make any time, and there was a collision.
Viewers, as you can see, it's a very, very cloudy set of circumstances. We'll go to a sponsors break and give you the result just after the break. Viewers, welcome back to the show. We're talking about this case where, as we said, the facts weren't that clear. I guess they weren't clear because there was dust everywhere apart from anything else, and a couple of drivers that probably should have been not so close to the centre of the road. Aki, in the first instance, what happened in the New South Wales District Court?
So His Honour found that Mr Cliff had failed to steer and control the truck to avoid the collision. Also found that Mr Cliff drove when vision of oncoming traffic was obscured. But then His Honour turned around and said, well, Miss Bacon, you're not completely clear.
Blameless.
You're also at fault. You're travelling at speeds excessive in the circumstances and you failed to keep a proper lookout. So he said, all right, let's go 50-50.
I mean, she was driving in the middle of the road.
Well,
And
Don,
she was veering to the left before the collision, so she was still somewhat in the middle of the road.
well, the codification of the law in relation to contributory negligence, I'll just go through a couple of things the courts look at.
Yeah, this is
but it's very similar.
Yeah.
I mean, the High Court in a lot of cases have looked at these issues. I mean, a couple of things you've got to look at is the standard of care required of the person who suffered harm is that of a reasonable person in the position of that person. So it's a reasonable person test, what the reasonable person would have done, and also the matters to be determined on the basis of what that person knew or to have known at the time. Now, I guess in this case you would have said that she shouldn't have been so close to the centre of the road in circumstances where you can't see what's coming.
Well, that's right. I mean, her own evidence is that she couldn't see a car length away because of the amount of dust in front of her. So being in the middle of a road is risky, using the words of
Proposition.
the enterprise.
Well, Don, that just highlights, I mean, you run the Transport Accident Department at a Wiki Carbone. You've just told us about a set of facts that are almost impossible to understand because you can't really work out with any clarity as to where these people were positioned on the road, albeit we know that they've come into contact, correct?
Yeah, that's right.
Now, these circumstances happen on a regular basis. You need advice early. So what do you suggest? People ring up...
Ring up in the Wiki Carbone, 1300 injured, or go to our website. We can. These sort of matters you've got to get onto straight away, Tony. I mean, if you get... In these circumstances, you'll get expert witnesses out there, take photos early because you'll see skid marks, point of impact, and also witness statements because their memory is fresh at the time, not 2-3 years down the track. So quite important you ring lawyers or ring us.
And also, don't be put off by her relative youth. This one's like a sleuth. You get out there, don't you, Aki? You take photos, a bit like a police, sealing off the area. It's pretty critical, isn't it?
That's right. We've got to do our investigations, Tony. We can't always rely on the police to get all the evidence at the time of the accident. So we go out there and do our own research and collect the evidence we need to support someone's case.
Exactly. And if you don't preserve it, it gets very complicated.
Correct.
All right. Now, just moving on quickly, the matter was appealed. It ends up in the Court of Appeal. In short, what happened, Don?
Essentially, the Court of Appeal held or dismissed the appeal, so upheld the judge at first instance 50-50, which I think is fair. And one thing about Mr. Cliff, I mean, the reason why he's also was liable is because he knew there was a risk of another vehicle being in the middle of the road, having used that road, and it was common practice of that road for people to drive down the middle. Yes. And they all knew about it. So I think it was a fair 50-50.
Yep. And Aki, the judge has got to exercise discretion. You're balancing all the facts and circumstances, right? And the courts have said, and I'm talking about the High Court, that to set aside an apportionment of liability, it must be shown that the failure to exercise the discretion involved in the apportionment exercise was unreasonable or plainly unjust. So it's a very, very hard thing to overturn. Isn't that correct?
That's correct. I mean, a lot of appeals with these type of matters regarding contribution aren't successful. No. Because it's just too difficult to show that the judgment was plainly unjust. So
exactly. All right, viewers, Wallace and Sherrill. It's a New South Wales decision again, 2015. Geez, the New South Wales people aren't very good drivers, are they?
They like to litigate too, Tony. So.
Yeah, it's a very... In fact, you might not notice, Aki, but before they amended the Civil Liability Act in New South Wales, it was the third most litigious jurisdiction in the world behind Texas and Los Angeles. Did you know that? Yeah. Texas and California. Yeah, third. Yeah, it's extraordinary, isn't it? All right, what are the facts of this case, Don?
Well, this is just an assessment of damages. It was a 58-year-old plaintiff. So what I mean by assessment of damages, there's no issue as to how the accident happened, Tony.
Well,
so liability was admitted. She was hit from behind, so that's it. Well, so she had an accident on the 4th of March 2005. She was a 58-year-old at the time of these hearing or the proceedings, but she was 47 when the accident happened. Yes. And what the court had to do was just to assess how much damages. Now, because of the restrictions in New South Wales, Tony, as to claim when you can claim pain and suffering, the thresholds, she didn't reach the threshold, so she couldn't claim pain and suffering. Yep. So the claim was purely based on economic loss, medical and like expenses, and also gratuitous
services
and the like. So everything but pain and suffering.
Tell you what, it was a pretty big sum.
Yeah,
we'll get to that.
Sure.
One of the major issues in this case was credit, wasn't it? They raised an issue of credit. That's the defendant.
Oh, that's right. There are a couple of things that viewers should know about this case. This particular plaintiff had some pre-existing injuries, some problems with her spine prior to the accident. She had an accident in 1985 as well as a subsequent accident a couple of months after the subject accident in this case. So, I mean, all of that has to be taken into account when assessing someone's damages.
But Don, a real positive for this particular lady, she didn't try to embellish her injuries.
No.
Well,
that's what the court found.
Yeah, she mentioned the earlier injuries.
Yep.
She gave you evidence as factual as possible without exaggerating and carrying on, correct?
She did, and one of the attacks that the defendants had on her credit was to say that during a certain period, a couple of years, then when she saw her doctors, I mean, mind you, this was nearly 10 years, this went to trial 10 years after the accident happened.
Yep.
So there was a certain period at the time where she didn't complain about any accident-related symptoms to her doctors.
Yes.
And that was a big attack on her credit, because they were saying, the defendant was saying, at the end of the day, how bad is it? She didn't complain. She's probably, the injuries have resolved, and are therefore trying to diminish her entitlement to damages.
Yes.
The court rejected that attack, saying, look, they accepted her as a truthful or witness of credit, and accepted her evidence to say, well, she didn't complain. Although she didn't complain, doesn't necessarily mean she was suffering from those symptoms.
Yep.
And her answer to that was to say, well, look, there was no point in complaining because my doctor said there's nothing that they can do for
Exactly.
me. And that was
Don,
accepted.
just to prove a point, right, how hard the law in New South Wales is, one of the major problems was an L5-S1 disc tear, for which surgery was being considered as an option but didn't occur. If that was in Victoria, you'd get a serious injury all day, every day, I would have thought. But in New South Wales, it's a very strict test, isn't it, Aki?
Yeah.
Anyway.
So it's a very strict test. So, look, just for the viewers, it just goes to show that, clients, you have to complain. Unfortunately, you have to complain, or else when you go to trial and you don't complain to your doctors about your symptoms, they will try and attack your credit.
Anyway, she got a large sum of money. That's the important thing. She got compensated. Don, end of the show. Thanks for coming on board as usual. Aki, thanks for coming back.
Thank you, Tony.
Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes on YouTube. Go to our social media platforms. And always remember to stay safe.